Welcome to the recap of Dominate Your Market. This is a recap of the October program, and I get the pleasure, Steve Riley, of walking you through a brief recap. So we're going to go through a straight review of day 1 and day 2 on this webinar presentation. So the things that we covered last time when we were together prior to the October workshop is the pipeline conversation and bottlenecks. We talked about building profit centers, and we talked about practice area profit centers, practice group teams. The profit center builder was a predominant exercise. We walked through the 10 reasons why we don't hire talent or superstars. And we walked through the Constellation Challenge, and we did a very brief introduction and review of the book, The Power of Habit. The agenda for the October workshop was the clearing, of course, focusing on what you made progress on, and we had tremendous success and some tremendous wins out of people that participated in this workshop. The Dominate Your Market scorecard, we walked through attacking tolerations, which I'll talk about briefly, using Kaizen in the law office. We introduced a concept called your process flow chart, and of course we had our traditional cocktail and reception. So let's go ahead and in day 2 we reviewed the 10 concepts of associate agreements, and these were the 10 key concepts, and there was a conversation led by Sean McNallis and myself over what we thought were the 10 critical components of any form of associate employment agreement. Mark Powers led a very powerful conversation via the DISC, which I'm not going to spend too much time on today because there's so much material that we have on our website and on prior audio recordings of the DISC, but it was a very effective presentation. We had lunch with the practice builder participants, which obviously we're not going to recreate on this, and we had some tremendous show and tell. Everything from an app, an iPhone app, which was unbelievable, and to some really cool things like a daily focusing checklist. Then we set up a conversation around the end of the year sprint, and then did my crucial goals in the CEO exercise, and we completed by 3:30. So what I'd like to do is just go directly to some of the content and a regrounding. So what I mean by that is the commitment and the game that we're playing in Dominate Your Market is that we're looking for independent confirmation first of market domination. Who agrees and who says that your law firm or you personally are the market dominant players? Number 2, we want more than half of your personal income coming out of profits from the law firm, from distributions that are not dependent on you doing the work, which means that your law firm has to be profitable regardless of whether you're in there cranking out work. Number 3, we're playing for 175 days off a year, and when we're defining days off, we mean no email, no phone calls. Number 4 is a viable succession plan that has been engaged, and what we mean by that is a little bit more. We mean we want a written succession plan. We want you to be clear about how it works. And number 5 is a major new delivery or marketing innovation. So those are the 5 great challenges, or the 5 things that we've laid down for you to aim for and play with. The Dominate Your Market scorecard is in your material, so if you're listening to this as a review or a recap, by all means do the exercise and score yourself. See where you're at and look through and look for ways that you can improve your score over the next quarter. We did not do the Migrate Life review, but we did play for a game called Attacking Your Tolerations. And the tolerations, if you're a long-term Atticus client, is a very favorite conversation. Tolerations are those things in your law firm or your personal life that suck life from you. And I like to, you can see them in financial areas, staffing, clients, home, auto, health for deferred maintenance around the health, social activities, certain relationships, and of course, spiritual development. And these are the 3 key elements that we've defined as a toleration. Usually they're invisible, meaning that you're used to them. You don't notice them anymore. They're just part of the landscape. They're part of your life, and they are indistinguishable. You just put up with it. You learn to live with them. So that's why we call them a toleration. It's just something you say, well, that's the way my life works. And number 3, they are the vampire gnats that drain you every time you get near them. But you don't see them anymore. They just suck your soul and they just drain you. And if you're not aware of them, that means that they work as gravity to hold you in place. They don't allow you to move forward. And one of the games that we're playing in the Dominate Your Market program is around innovation. And if you're not in a position where you feel like you have a lot of energy and a lot of excitement and a lot of freedom to create, then tolerations and things like tolerations will hold you in place. So if you're following along and you're doing this, my suggestion is that you take a break and complete the blank tolerations worksheet that we provided you. And here are some of the examples of the tolerations we did in the class. My paralegal not coming in time. My windshield wipers need to be replaced in my car. I need a second monitor for my computer and I haven't gotten one. I'm not getting my annual checkups either with the dentist or the doctor. My wardrobe is a mess. I've been waiting to lose 10 pounds to buy any new clothes. My favorite shoes need to be repaired. My closet's a mess. It's been disorganized. I haven't organized or cleaned it out in a long time. My to-read stack is mocking me. And this is one of my favorites, especially for us attorneys. We get a tremendous amount of written material that we expect to read and stay current on in our trade journals. And after 6 months to a year, it just becomes a mountain of to-dos, and it starts to mock you. Your car needs to be washed and waxed. And last but not least is my desk is cluttered. So these are all things that could be examples of tolerations. So if you're doing this and you're doing this to kind of get yourself either recapped or review of the program, I would suggest you pause the presentation here and just do the tolerations worksheet. So let's assume that you've completed that, and one of the exercises that we did during the worksheet, or during the workshop, excuse me, was what one small toleration can you do today from the workshop. So if you're following along, once again, pause this presentation and see what toleration you can go knock out right now. It might be something simple that you can make a phone call on, something that you can delegate to somebody, but go do that so it's taken care of right now. So great, hopefully you've knocked out that toleration. And what we're talking about next is a review of the homework, which was a book called The Spirit of Kaizen. Now, this was a very powerful book, and it introduced a very simple concept. And what we're trying to do is connect the dots between the Power of Habit book and the Kaizen book. And the point that we're trying to make through the Dominate Market program is that if you can learn how to shift and change habits for you and your law firm team, it can create a massive competitive advantage for you in your life. And just as a review, the essence of the habit loop was there was a cue, a routine, and a reward. And we talked a little bit during the workshop about how that plays out. What we're playing for is looking at using Kaizen as a keystone habit in your life and in your law firm. So you want to look at this concept of Kaizen as a tool for you and think through it as how can I make Kaizen a lifelong habit for solving problems that foster good change for you in your life. And we're looking for, first and foremost, how do we successfully implement Kaizen in your life, so successful change? How do you use Kaizen as a way of helping others to change? And most importantly, if you're going to play for innovation, you have to start thinking through how do you help your law firm team manage the fear that will develop around change. If you're playing a big game and dominate your market, there's going to be some changes that you're making. So the question becomes, how do you help your law firm team and those around you that are supporting you in this game cope with fear? And Kaizen is one of the powerful tools that you can do to do that. And during the workshop, we hit a few highlights of the book. Number one, is that your body, your brain, is designed to resist any form of radical change. The point in the book was that your amygdala, which is the reptilian part of your brain, sometimes called, is the part that cannot, it's your fight or flight component of your brain. And it really can't distinguish between good change or bad change. It can't distinguish between a saber-toothed tiger or a really mean email. It just doesn't like it. So if you go into overwhelm, it completely hijacks your brain so that the fight or flight syndrome is fully engaged, and all these really tough, intense hormones are raging through your body, and it stops the creative process of your brain because it's more concerned about survival, not creativity. So Kaizen is really important as we start to set up the groundwork for innovation. Any form of change can be frightening. And to accept your brain, to accept change for innovation, transformation, creativity, Kaizen becomes a very, very powerful tool. So if you decide that you like Kaizen and you want to implement it in your law firm, there's 4 key concepts. First is the concept of Kaizen. So if you're introducing this to your team and you're having a team meeting, you want to introduce Kaizen by what it means. Good change, usually good small change. JoJo usually means slowly, gradually, steadily, and this is really the concept that the author talked about as being at the heart of Toyota's long-term strategy. It wasn't looking for radical transformation immediately. They knew that this was a long-term game, that they were integrating JoJo, slow, gradual, steady change, at the heart of Toyota. And number 3 is the Andon Cord. Now the Andon Cord, if you want to, you can click this link right here, which is a YouTube video that does a wonderful job explaining what the Andon Cord is and how it's important. But inside your law firm, you want to think through what's your Andon Cord process, because the Andon Cord, for lack of a better word, is the thing that your team will yank on when there's a crisis, a quality control crisis. So if you look at the video and you think about this, you want to ask yourself, what is your Andon Cord process? Because more than likely your team will create 2 Andon Cord processes if you don't create one for them. One will be they will email you, or number 2 they will come in and absolutely interrupt you. So if you're going to implement Kaizen and talk about small changes, there's going to be a lot of quality control issues that your team will want to talk about. But if they're not in a position to feel like they're being heard or addressed, they're not going to bring them to you. So you want to think through what's going to be your Kaizen process around the Andon Cord. How can you teach your team to implement the Andon Cord idea? So I would recommend that you watch the video, and then that will make more sense after watching the video. And the whole essence of Kaizen is that we're trying to talk about Kaizen as being a probable progress towards change versus the radical innovation as a concept of possible transformation. So this is the difference between get rich slow or get rich quick. Do you transform your practice slowly but consistently with an 80% probability of success, or do you go for get rich quick with radical innovation? And most of the time, the Kaizen approach will win over the radical innovators. You just look in the marketplace. The companies that are just slow, methodical improvement players, they slowly but surely get rich very powerfully, and there are companies like Apple Computer that really has introduced radical and powerful innovation, but those are fewer and far between. And you have to look at yourself as an attorney, as a practitioner. Are you a radical innovator, or are you better adopting the Kaizen approach in your practice to support change and support innovation? So the question becomes, if you buy into the Kaizen philosophy, where do you start? And first we want to look at briefly at the Deming's rules. And this is first, look at the resources you have. So that doesn't mean go out and spend a whole bunch of money. What can you do now and how can you use it? Number 2, invite everyone to participate. Everyone's perspective and opinion will absolutely matter. Number 3, remain alert for problems. And this is where I was talking about the Andon Cord. Start paying attention to where the problems are. If we can't solve them immediately, put them on an Andon Cord list. And number 4, always look how this is going to impact the end user. Sometimes you'll see change being implemented, but the change we haven't thought through the collateral impact of the change on the customer, on the clients. And number 5, make very small steps towards change. We don't have to do anything radical. We just need to be progressively improving the firm every single chance that we get. And if you're not sure what to do, ask small questions. And small questions, the point the author made, it makes it easy for your brain to come out and play. It's not going to be threatened by the overwhelm of change. It's going to hear the small question, and here is a safe way of thinking creatively about solving the issue. And how do you know what questions to ask? Our suggestion is you look at areas of frustration. In the book, the author talked about morale, cutting costs, improving quality, developing new products and services, increasing sales, improving health, and reducing expenses. Some of the ideas that we suggest you look at is ways of increasing referrals, increasing the quality of referrals, ways to improve your time management and focus management, how do you improve the quality of your personal time off or your staff's time off, and how do you integrate appreciation. So there were some things that we played with as an exercise to create Kaizen questions inside the law firm, and that's an exercise we did during the class. But we also created an example of a worksheet. Now, what you're looking at on the screen is an example. So you have a blank Kaizen worksheet that I would suggest that you look at and do the exercise maybe for 15 minutes coming up with your own Kaizen questions. These were just hypotheticals that we came up with for the purposes of this exercise. So if you're following along in the workshop and you're trying to create the best experience you can personally as you re-listen to this or you listen to this for the first time, I would suggest you put the presentation on hold here and go work for 15 minutes on your Kaizen worksheet. Okay, well, hopefully you've taken the 15 minutes to work on the Kaizen worksheet, and I would suggest that you pick one of those to implement in your firm today and see how you can make that work inside your firm as a Kaizen process. Great. So if you were at the workshop or if you're watching this afterwards, this was the last concept that we introduced on our first workday, which is called your process flow chart, which is creating visual workflows in your law firm. And this was a really breakthrough concept for, I'd say, about 80% of the people there, because we had a really strong discussion about how lawyers communicate. And majority of lawyers are trained to communicate by written word and verbal communications. So we are not visual communicators. We lead with words or discussions. And the problem with that is that we create these really great checklists. And this is an example of a DUI checklist that I got my hands on. And this is how a DUI process works in this law firm. Now the problem with this is that if you're training a new employee is that this is very complicated and very complex. And it's good for lawyers because this is how we were trained in law school. Most of us would look at this and go, yeah, how else would you approach this? There's no other way to approach teaching someone this. There's no other way of processing information than through a really great, cool checklist. And, I've recommended a lot of checklist books. I used a lot of checklists in my practice. I still use checklists to this very day. But there's a breakthrough way of communicating that I think we're not used to. And the problem that we're, as lawyers, and how we're trained as lawyers, is I think we are confronted with three ways of communication that we're really not prepared to think through. Number one is verbal and written communications that are complex will create confusion. My experience is clients and staff generally don't want to learn. They just want to know how to do the job, or they just want to know how to hire you. So the question is, how do you make it easier on them to learn certain new topics? Number two, the more you talk, the less you say. And my experience is working with lawyers is that if somebody doesn't get something, we just talk more. Sometimes we talk louder. And the fact that you're talking louder or faster doesn't necessarily mean that the person can hear you any better. Number three, usually we're under so much time pressure, we don't have time to think about how to improve our communication. We just repeat it and keep moving. So consequently, these three challenges for communications really, I think, impair us in the growth of our practice. So we're playing for dominating your market. We have to have a breakthrough in how we communicate. So the concept that I want to lay down the groundwork for is paying attention to how people learn. So what's the number one way that people learn? Well, if you think about it and you do some research on this, 65% of the population are visual learners, 30% are auditory, and 5% are what's called kinesthetic learners, which means it's emotive or they have to physically touch something. But if we look at this, the bulk, almost 70% of the population, so that basically tells you 2 out of 3 people, learn visually. But yet as lawyers, we assume that they learn as auditory learners because we try and talk to them. Number two is, why does visual matter so much? Well, visual matters because 75% of your entire sensory perception is dedicated to vision. So if you study how your brain processes information, 75% of the brain wiring is to visual processing, which is 20 times more than touch and 60 times more than hearing. And this comes from one of my favorite books, Blah, 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 Blah by Dan Roam. So 75% of your entire sensory perception is dedicated to vision. So if that's the case, what would the value of visual clarity be to you and your law firm? What would that mean? How could that help? Now, generally speaking, whenever I talk about visual clarity with lawyers, I get a lot of pushback. And they're like, well, we don't know how to do that. So I've put together some examples of visual clarity that I've seen lawyers work with. And I'm going to walk through, first and foremost, very rudimentary visual clarity to some really, really great examples. So here's the first one. Is it possible? This is an example of a personal injury pre-suit process. Now, I really like this one because it shows here the initial to client meeting, case manager, demand letter, negotiations, and litigation. And it goes through the process. Typically, when I did plaintiff's work, this was probably a 9-month to a year process. This would be really powerful not only for training staff, but also telling clients, this is how long the process works, this is how come the process takes so long, this is, step 1, step 2, step 3, step 4. So this is really, really powerful. Simple. This was done on a Word document by a paralegal. So this is nothing creative, no artists involved, no fancy software. This is basically Word. Here's my second example, and I found this one on the internet. This is an example of the family law process. And this is a little overwhelming. And this is an example of maybe too much on the one page to explain to clients how this works. There's probably like 4 or 5 processes here that need to be unbundled. But the truth is they pretty much got everything on one page of how the family law process works. The next one is probating an estate. And this is an intestate estate. So this was really great because sometimes probate lawyers will say things like, it's a hurry up and wait process. Well, that doesn't really tell anyone anything other than hurry up and I tell you what to do, hurry up and I tell you what to do, hurry up and I tell you what to do. And so when you're quoting fees or you're trying to set a price for this type of work, it really doesn't help the client either on their trust level or understanding if you don't have a way of explaining it to them. I've actually seen lawyers give copies of statutes like here's why it takes so long. But if you look at it, this is a really simple picture. And this is a very generic one, so it may be different in your state, but you can create it any way you want. Petition, notice of hearing, file contest if there is one, preparation for hearing, order appointing the PR, let our executor, depending on your state, letters of administration with the breakdown of steps over here on the side, and then distribution and settlement. So it is a pretty simple chart, but I think it absolutely captures. And this is my favorite, and I got a big chart out of this one. This one is an example of the patent process, and this is where the client discloses the invention to the firm, walks through the process, and walks through how the firm, step by step sets up a patent process. What I love about this is if you look at this one carefully, it was clearly written from the lawyer's perspective because they talk about fees in chart 1, in step 3, 4, 5, 6, and 7. So of the 9 steps, 8. So of the 9 steps of the patent process, 5 involve fees, which I thought were pretty funny. That's just me. Great. So let's look at, whoops, I'm going backwards, sorry about that. Let's go to the next one. This is a brilliant one that was done for the home sale process for home sellers. And I like this one because this one's really fairly well thought out. And this actually came out of a process out of a class where I introduced this concept of your process flowchart. And an attorney did this off of free software he downloaded off the internet and on his iPad, and it took him about an hour. Now this was a real breakthrough for him because not only did it explain why the process takes so long, it walked through each step of the home sale process. It talks through each thing that needs to occur during the home sale process, and it also identifies the task that the client has to do in green and the task that the law firm has to do in yellow. With a little bit of work, this could be just an absolute killer breakthrough tool to talk to home sellers about how the process works. So I've talked to him about some things I'd like to see him change in this. But this is a phenomenal example of something that occurs every single day that could simplify the explanation for not only the client, the lawyer, the realtors, but also for training. Bringing someone staff to do this process, it could tell them exactly each step of the process and what needs to occur. So visual process can create amazing training advantages for you. And the next one is an example of a brief probate one, and this is just a probate one, how long the steps, what occurs at each steps, and how long it's going to take. So this is a great example of how to do this. I'm not going to spend any time on that one. The class favorite was the immigration one, which was what part of immigration don't you understand? And this is a flow chart kind of explaining how immigration works. My favorite part about this one, and we have examples of all this for you to download, is the people getting kicked out. So if you're in a position where you're communicating to clients the importance of having a lawyer involved or the importance of following the process, nothing could be more powerfully than showing someone booting you out of the country on your immigration process. So if you decide, if you're looking at this and go, wow, this makes a lot of sense to me, I really would like to do this, then the question becomes, how do you do it? And I've identified a couple simple steps to get you started. Number one, adopt a mapping legend. What do I mean by that? Well, you've got to adopt some language or visual language that you can use to think through concepts. And this is a really great example I found on the internet on process flow mapping symbols. And the blue rounded rectangle here means start or step, start or stop. The diamond means decision point. That means you got to approve, reject, say yes or no. And then the green sharp rectangle here is an activity. And then a connector means that you can have a connector moving you to a different process map on another sheet. And then, of course, arrow means direction of the flow. And this is simple and elegant because this shows you how to boil or how to make tea. So you start, so you can see the blue diagram here, start, you grab the kettle, has the water boiled? No. Then you wait, then you go back and start the process over again. Has the water boiled? Yes. Pour it into the mug, drink, in. Process ends. So if you're going to look at doing something like this in your law firm, you can absolutely adopt these types of symbols to use, or just draw circles, whatever works for you. The whole idea is that we get it out of your brain on paper. My second suggestion is start small. And now this is an example of a law firm I personally coach, and this is their process for routing incoming phone calls. Now I'm not going to walk you through this, but we spent about 15 minutes during the workshop walking through this because it was very powerful. This lawyer was personally taking every incoming call for whether somebody asked for him or if they're a new client or anything like that. They just were getting completely gunked up because, he was spending 2 to 3 days a week just on the phone dealing with phone calls. And he tried to create a checklist for his staff, but the checklist or process that he created was written and the staff didn't get it, and their new receptionist was just having a difficult time understanding it. So it took us a couple of hours, and we put together this really simple process map, and we introduced it, and within 15 minutes she understood exactly how to handle phone calls. What was even more powerful about this is that now he had a diagram to teach any receptionist or anyone else on the staff how the phone call process works. So, he has a separate phone intake sheet. They have thresholds of where, value of cases should be. So this is a really great way of looking at just tracking your phone calls. Now, routing phone calls. Another way that I've had lawyers start small, and they're like, okay, I don't really get this. I don't understand how to do it. Start a process map on how mail flows in your office or how email flows in your office. Just simple communication or pleadings, how pleadings flow in your office, whatever that may be, because you can start small and start to diagram processes inside your law firm that will make a huge impact for communicating to clients, communicating to staff, and most importantly for training to speed things up and along as you hire new staff. Now, if you do this, I'm going to recommend that you use a military concept called BLUF, which stands for bottom line up front. So I really wouldn't start your process flowchart until you are clear about what is the purpose of the flowchart, meaning who's going to read it. Is it going to be an internal flowchart that only staff reads and you read? Or is it going to be one that goes to clients? Is it going to referral sources? And then you want to think through, why does this process flowchart matter? Like why is it important to someone to read this? And then think through, what's your ideal outcome when they look at this? What are we trying to communicate? What would be ideal for you as far as what you want to communicate out of that? And so the homework was that we gave everybody the opportunity to work on some element of their practice, whether that's a sales process or a production process. So I suggest that they work on some part of this. And we didn't do any of the exercises on this, but the homework that was assigned is that you're required to bring your process flowchart to our next workshop to share with the group. I don't care if it's black and white. I don't care if it's color. I should bring one that you can present to the group and share with the group. And that, is, my friends, is the end of day 1. So we'll go to day 2. Day 2 agenda was reviewing the 10 key concepts of associate agreements, communicating through the DISC, the end of the year sprint, and my crucial goals. And then, of course, homework, which I'll review with you briefly. So this was a very powerful visual presentation because the ever-brilliant Mike Wells designed this one. It's called Protecting the Pack, the 10 Key Concepts in Associate Compensation. So why create a formal agreement? If you're going to hire lawyers and you're going to employ them to do things for you as part of your dominate your market strategy, if you don't address the following fears and think through the anxiety points that you have, you won't grow with any form of aggressiveness. You will just kind of flounder a little bit on your growth. So ultimately what we want to do is have a standard agreement that addresses the key issues that you have concerns about when hiring attorneys so that you'll feel protected and you'll grow. If you don't take any action on this, you're just going to continue to have a haphazard or fuzzy method of hiring new associate attorneys, and worse, that you'll never communicate your expectation and you'll never be clear with them about what you're judging them by. So you getting the clarity of your expectations is absolutely critically important in hiring an associate, or quite frankly any form of relationship where you're hiring someone to do something for you. And then the one thing that Sean McNallis and I both talked about and we're very clear about is, do we really need an associate attorney? The only reason I would ever hire an associate attorney is if the task can't complete it by a legal assistant or a paralegal, or I can't outsource it. And generally the whole staff, everybody in the workshop concluded the only thing that we absolutely need a lawyer for is going to court. Everything else generally, I'd say 80% of most work that most law firms are dealing with, we can train paralegals or paralegals or legal assistants to do in lieu of associates. But if we are going to hire an associate attorney, the first question we've got to ask is, why would an associate attorney ever want to come to work for you? What is the reason a rock star associate attorney would ever come to work for your law firm? What is the career path for that person? What's in it for the applicant beyond just a job? Now, we had a good discussion about that. Obviously, I can't recreate that discussion on this webinar, but I can at least review with you the 10 key concepts that we addressed. Number 1, don't steal my clients. And what I mean by concept 1 is making sure that you've addressed up front what is the process of solicitation of clients by a former associate. Most states do not allow non-competition agreements. If your state allows a non-competition agreement, then this is very easy. The majority of bar associations, the majority of states forbid covenants not to compete because they want the attorney they want the clients to be able to work with whatever attorney they want to. They don't want any restrictive covenants on who can work with what lawyers. So if you're going to hire a lawyer and you are concerned about them leaving, then you need to address on the front end what is the process to let clients, and specifically the associate clients, it doesn't have to be a firm-wide notice, it just has to be the clients of that particular associate attorney or the cases that associate attorney is working on, that's who needs to get the notice. Now, I forgot to mention at the beginning of the presentation is that also on the Dominate Your Market Group Facebook page, we have examples and sample language for you to use and modify, which of course everybody loved. But you got to be clear, this is stuff that we're giving you samples of. We're not saying that it's relevant, you know, it may not be relevant for your state, so you have to look at that. Number 2 is don't take my referral sources. Now, what we've seen happen is associates leave law firms, and both Sean and I have seen this where associates leave law firms and the associate starts to solicit referral sources of the law firm. Now, I want to be clear about this. You can absolutely have a covenant not to compete with the associate attorney on not soliciting referral sources, provided that referral source is not also a client. So, for example, if you have an agency or an institution or someone who sends you work, the lawyer can agree not to solicit them and enter a non-compete as it relates to those relationships. So these are non-client referral sources, so you can absolutely knock them out. One of the points that Sean made, which I think is a very good point, is that you want to pay attention that a lot of senior attorneys and owners of firms are handing off social media, blogging, Facebook, LinkedIn, Twitter accounts to their younger lawyers, typically to the associate attorneys, with the hope that the associate attorneys will manage them. This is kind of a really dangerous thing to do, because the question then becomes who owns those contacts after the associate leaves. So this is one of the issues that you want to start thinking about. And there's a really wonderful article that Sean found and that Mike Wells will put as a link on our Facebook page, is who owns the LinkedIn contacts. So this is this has become a bigger and bigger issue with social media being such a prominent component of top-of-mind awareness strategies. Great. Number 3 is don't take my stuff. What do we mean by that? Well, if you spent time and money developing processes, training manuals, systems, client forms, and in some cases you've created intellectual property, then protect it. If it is intellectual property, use trademarks, service marks, trade secret laws to protect it. Most states have either service marks or they have trade secret laws that allow you to identify that your processes, your office manual, how you do things are actually trade secrets, and they can't take them if they leave your firm. Now, I want to be clear about this. If you think it's valuable, call it a trade secret and identify it now. You can't do it after the fact. It's very hard to call a trade secret after the fact. So our recommendation is if you got intellectual property, it's not difficult to protect it if you got the right language or the right process. So if you're concerned about this, do an intellectual property audit of your own and figure out what's worth fighting over so you can integrate that and protect that in your associate employment agreements. The other thing about this is be clear that you also have the right to lock, and we communicate to the employee about this, or the associate, that you have the right to lock them out of the computer as soon as you know. As soon as that you think that they're leaving or there might be an issue with them leaving, typically you have the ability to lock them out and protect the law firm, and you can address that in your agreement. Number 4 is don't badmouth me, and that's just talking about how you spent time and money developing a brand, and that brand is important, and that brand is your reputation. So you want to make sure that if your former associate leaves, that they don't badmouth you, and you have to make a decision whether you want to badmouth them. So you need to put non-disparagement language in your employment agreement, so it's important to protect you. And one of the ways that Sean pointed this out, and I think was very brilliant, is start this problem before it starts, because if an associate attorney or a prospective associate attorney comes in the door and starts to badmouth their former employer, then you know that that's probably not somebody that you may want to hire. You know, it's probably kind of dangerous, and it's occurs where somebody comes in and starts bad-mouthing their former employer in the first interview. Great. Let's talk about number 5, don't take my stuff. You've got great don't take my staff. We've already talked about don't take my stuff. Don't take my staff. You've got great and well-trained employees. If an associate leaves a law firm, he can take his clients, but not his assistant, paralegal. And if you want any vendors, you can knock them off of any vendors. And this is a twofold strategy. You can first and foremost have the associates sign a non-solicitation agreement where they'll agree not to solicit any of those people. But this is a very powerful one where you can have non-lawyers sign non-compete agreements. One of the attorneys in the class talked about where he wants to hire away a very, very good employee at another law firm, and this person is a case manager. They're not a lawyer, and that person has agreed to a 1-year non-compete with her current employer. Well, they're kind of hard to bring on staff, and the law firm doesn't want to have a fight, but it really, really is one of these things where you could, if you've got key non-lawyers in your firm, having them sign a non-compete is completely easy to do. So my recommendation is if you have great people working in your law firm, don't let them get stolen away from you. Have them sign non-competes. Number 6, don't do nothing stupid. If you did, tell me. It might sound obvious, but you want to think through how you want your associates to be upfront if they have created an ethical or malpractice problem. Don't bury it. Don't hide it. Don't hope that it goes away. You want them to talk about that and be really clear with them that your expectation is if there's a problem or screw up, they're to bring it to you. They're to bring it to you. So this is a before-during process. Means before you hire someone or while they're employed for you, you want to let them know this is how you want issues like this to be handled up front, disclose it. So if there is an issue, it can be taken care of. Number 7, don't be a prima donna. Follow our rules. Sometimes we see lawyers kind of create how they think things should work, and young associates thinking, well, this is how we should file things. This is how we should send emails. This is how we should, innovate and make changes. So make it clear with your young associate or your associate attorney. Make it clear that your firm won't accept any rogue innovators, or at least not without permission or adult supervision, meaning that there's a process for changing your systems. And be open with the process with associates on the front end. So be clear, no changes to anything without our permission. We want you to follow our procedures, our systems, our protocols. That's what we want to do. Now, one of the recommendations that Sean has is before hiring, look at the candidate's DISC profile to see how compliant they are with rules and their tolerance for risk-taking. If you're hiring an attorney that has a high tolerance for risk, they're going to be completely more inclined to think they will be, but more than likely they will be much more inclined to take risk and act independently outside the systems that you've created. So the question for you is how do you address that inside your agreement? One of the things that we'll talk about in a minute is the DISC profile and how powerful that is. 8, don't make me regret this financially. One of the things that amazes me about lawyers is they don't think through what is the financial expectations around the performance of an associate attorney before hiring them. And Sean and I both agree that the rule of 3 is a great benchmark. So what we mean by that, if you're paying an associate attorney $50,000, then we want to make sure that the associate attorney is generating $150,000 worth of revenue for you to, for them to be profitable for you. And the rule of thumb is 1/3 to the associate, 1/3 to overhead, and 1/3 to the profit of the firm. So I don't care if you work in 90-day windows. I just want you to think through what is the impact of this and make sure that you have a plan before you hire that associate attorney. So this is really, really important. I think our recommendation is that you think through maybe raising your rates, limiting the type of cases you take before you hire an associate attorney, and make yourself as profitable as possible. Even look at hiring a non-lawyer before you invest in hiring an associate attorney, because this is where lawyers really seem to create a lot of complexity in their practice by hiring an attorney first before thinking through the economics of that move. Number 9, don't expect to be a partner unless you act like one. What's the partnership track? Sometimes young lawyers think that time spent in the firm equals partnership. If I put in 5 years, then I should be a partner, like a tenured professor at a university. You put in the time, you get the result. A partnership track that controls the expectations or think through what that looks like and communicate that to a really important, to a real new hire. This is the process to become a partner. Beyond their skill, beyond their personality, beyond their values, beyond their legal judgments, what are the things that you're going to measure and judge them on? Now, both Sean and I, working with hundreds and hundreds, if not thousands, of law firms on around partnership issues, it usually distills down to 2 major things, and that's it: revenue production and business origination. So if you're talking to a young lawyer and you're not clear what your partnership track is, you're going to be really clear about these 2 issues. First and foremost, you're going to only bring a partner on who can produce revenue, and number 2, only bring on a partner that can produce business. Now, in some firms, there may be a split track where you have service partners. It may be that you have a distinction between a rainmaking partner and equity partner, but generally speaking, these are the 2 things that we find over and over and over. If you are going to have a service partner, then you're going to end up having like a 2-tier partnership, where the rainmakers, the business originators, may actually be making profitability off the service partner's work. Though we had a brief discussion on distinguishing what a service partner looks like and what a equity partner looks like. And Sean and I both agree, no matter what, whether it's a service partner or equity partner or whatever concept you create, we expect a equity or capital investment by the new partners before they join, so it's really clear that they have some skin in the game. Number 10 is we don't train our future competitors. And what we mean by that is we don't want you to train your competitors, nor do you want to train your competitors. Be clear on the front end what you need. And one of the things that you want to pay attention to is the behavior profile of your partners, your future associates. Because your future associates may come in with a certain profile, which will make them more than likely the type of person that starts their own practice. The example that we used is someone who's a high D on the DISC profile, because they're going to be very, very risk tolerant, and will more than likely be the type of lawyer that will found their firm on the back of yours. The example language is posted on the firm's private on the firm's private Facebook page. I nearly said Grapebook page, which I have no idea what that is. If you're not participating on the private Facebook page, then email Mike at atticusonline.com, and he will send you the Word file directly. Great. So those were the 10 key concepts of associate compensation agreements. The DISC behavior profile really talked about how we might perceive things, and Mark walked us through some perception exercises, some of which you've seen in the past, and distinguishing how we see things from our viewpoint, even though we may think that we're being unbiased. Our DISC profile will really bias our whole view of the world. And the 3 points he was making is that understanding the behavioral benefits, understanding the communication benefits of understanding the different DISC profiles can really impact your staffing and hiring. Number 2 is understanding your profile and how it impacts the firm. And number 3, understanding that more than likely your profile is setting the tone and the culture for the entire firm. And we walked through a conversation, have you ever mismanaged, like when you were working? What did it have? How did it have an impact on you? What did that mean? How did it impact you over a period of time? And the DISC is basically a great way of understanding how you would prefer to be managed with, or how you prefer to be communicated with. And the DISC is not a values judgment. It's not doesn't measure skills, experience, education, training. Those are things that you're going to get from the person through the resume, through interviewing. The DISC is really talking about how they perceive their behavior, and it's typically going to be flexible and dynamic. It's going to be situational, meaning that it may adjust depending on the situation the person's in. And there's 4 major concepts. Dominance, which is how you handle problems and challenges. Influence, how you handle people and influence others. Steady, or steadfastness, is how you handle change and pace yourself. And compliance, how you handle rules and procedures set by others. And each of these have a way of showing up in the world. And so this is a descriptors or characteristics of a high D. And they're going to be described as adventurous, competitive, daring, innovators, persistent, problem solvers, self-starters. My experience of working with high Ds, their motto in life is, oh yeah, let's go. These are the people that are going to take the hill and not be really, really sure where they're going half the time. They just know they're going somewhere in a very, very powerful way. And if you're a high D, you want to look at this because they have certain ideal environments, and most of them have created the ideal environment in their firm. The value to the team, the tendency under stress, possible limitation, and the emotion of a high D. Typically, they have high expectations, and they're prone to anger, and they are really, their response is to fight tooth and nail. And if you've been in a litigation firm with a bunch of high Ds, that's how they get along. They just fight with each other and fight with each other. I mean, they fight with each other, they fight with their partners, they fight with other lawyers. Put a couple of high Ds in the room and just let them wrestle to the ground. High Is. High Is are high influencers. These are charming. These are people that want to be liked and like to be liking people. They are going to be trusting and sociable. They will typically want to interact with people a lot. And there are going to be, I like to joke, I usually say the high Is are the people who put lampshades on top of their heads and lead the conga lines at parties. Now, isn't that always true, but it's kind of what I've seen over the years between working with high Is and employing high Is. They typically are very sociable creatures and actually get energy from talking to others. They have a tendency to be name droppers. They have a tendency to be very concerned about whether they're liked or not liked. When I'm working with a lawyer who's a high I, I generally know that if they're charging fees, that they typically undercharge because they would rather be liked and get the case than make the case profitable. S. A high S or steadfast character, or steadfastness, is usually, these people are the Rock of Gibraltar. They're usually good listeners, they're patient, they're sincere, they're stable. They typically want to avoid any form of controversy or any form of fights. Their conflict response is to tolerate people, and they're usually very non-emotional. They're almost, when you're talking to a high S or steadfast personality type, you'll hear them in a very calm and logical process. Terrific with clients. The downside with a high S typically is that they also hate change. So the Kaizen conversation that we had earlier is really crucial to understand and utilize when working with someone who's a high S. A high C, which is very analytical. C stands for conscientious. High C is usually going to be a they're going to show up like a perfectionist. They're going to be very accurate. They're going to be precise. They like to show up on time. They like to be dotting the I's, crossing the T's. And they're really powerful when playing on a team. Some of the downsides of the high C is that they typically are going to be fussy, sometimes overly critical, have a very high standard that they expect other people to live up to. And usually they're a stress reliever, and this is a great one because this is my DISC profile. CD is my DISC. Is my idea of stress relief is not hanging out with other people, which is what a high I likes to do. Mine is being left alone. So I have most of my recovery time is when I'm left alone. And here's some examples. This is a DI, a high D, high I. If you look, there's a low S, low C. So this is going to be a hell of a rainmaker. They're going to go out and, this is a classic, probably litigator profile. And they're going to have stronger tendencies. You're going to see these two tendencies of domineering and influence show up everywhere. They're going to be very prone to taking high risk and they can handle change. This is another great profile of this would be an awesome litigator. This is a high D, high C, so it would be domineering and highly analytical, so they're going to pay attention to the details. Actually coach a litigator like this, and he's killer. So great. And here are examples. So we walked through some of these examples in the class. If you were trying to describe any of the profiles, and of course Mark came up with this because it involves golf. Mark could not come up with another example other than golf. I think this is the main example. How does golf fit into a presentation? So here are, if you run across 4 different characters on a golf course. One's a great scorekeeper, plays strictly by the rules, and cleans their clubs frequently. Is that a high D, I, S, or C? More than likely it's a high C. Golfs the same time every day, same place every week, and has an umbrella in case of rain. More than likely a high S. They like routine. They like the same thing over and over and over and over. I have a few high S's in my life. I know this. And then a spends time in the clubhouse talking to everybody how the day was, you know, how their family, what's going on. More than likely that's your high I. High D drives the golf cart aggressively, tends to play through groups, and is annoyed with everyone because they're in their way. The high Ds like to win. So that's a great one. Here's another one for gardening. They belong to garden clubs. They grow vegetables and have a 3-year supply of canned corn. That's great. Does not allow weeds on their own lawn and notifies neighbors upon seeing weeds on their lawn and hires someone to mow their lawn. So this is great. So your high I is more than likely belongs to the garden clubs. Your high S is more than likely grows their own vegetables and has a 3-year supply of canned corn just in case. A high C is probably someone who doesn't allow weeds on their own lawn and notifies neighbors upon seeing weeds in their lawns. And a high D will more than likely hire someone to mow their lawn. This is another great one. So I'll do this one and then I'll move on because I like this one. So waits in line. They're getting on the elevator on an early morning. Waits in line, but if it's too crowded, takes the stairs. Next one, holds the elevator to let others in, saying there's always room for one more. Walks up, gets on the elevator, pushes the button to close the door, you know, while people are coming to try to get on. And the last one is counts the number of people on the elevator, and if it exceeds the weight limit, makes someone get off. So more than likely, our number 1 is a high S. If it's too crowded, they're going to take the stairs. Number 2 is our high I, which, you know, always lets other people in, is very social. Our high D walks up, gets on the elevator, and pushes to close the door. And of course, our high C does the math and says, wait a minute, we've exceeded the weight limit, somebody needs to get off. So these are just fun ones. I'm not going to do the grocery one. And really what we're trying to do here is have you shift how you look at the DISC, because the DISC is powerful, not only understanding how you like to see the world operate, but really getting clear on how you want to communicate to others. So looking at your profile, if you want to really make an impact, you don't want to talk to people on how you prefer to be communicated with. You want to talk to people in the way they prefer to be communicated with. So if you're managing staff, if you're hiring, are really powerful if you understand how to talk to clients in their DISC profile. So you're able to communicate with a client in their DISC profile can be really effective. Makes a huge difference and can really reduce their stress. So this, if you want to spend some time looking at this, you can stop the presentation and check this one out. And we walk through a little bit about, you know, how these different profiles make a difference. Good. So that's basically all I'm going to say about the DISC presentation. If you want some more, let us know. Let Mike know. We've got a whole bunch of audio materials on the DISC and a whole bunch of written materials on the DISC. We did a show and tell presentation, which we really can't recreate on this webinar because people did show and tells. Great. So here's a next to the last concept we introduced. I'm going to walk through the end of the year sprint. I'm going to walk through the top 10 crucial goals, and I'm going to walk through homework. So end of the year sprint, we suggested that you set up the end of the year very powerfully and use the end of the year as a strategic planning tool, so that the end of the year is like a finish line. You sprint to it with intensity versus allowing it to sneak up on you like a mugger and clobber you. We want you to get focused and use the year end as a very, very powerful tool. The guidelines are the key reasons for a sprint is the compressed timelines provide intensity. It gives you opportunity to provide leadership to your team, and it also gives you a way to practice your Kaizen way, your habit of acknowledging changes through Kaizen inside your practice. So what we did is we flipped over our top 10 crucial goals and we did a mind map. And so if you're following along, take a piece of paper, divide it into 4 squares so that you have 4 squares, 4 quadrants. Upper left-hand corner, I want you to put your top 10 most valuable cases for the year. You can just pause the presentation if you want to do this, but I want you to rank them by dollar value. So your most important, your most valuable case is number 1, and then your top 10 are identified because these are cases that I want you to crank on and get done by year end. Second quadrant, which will be the upper right-hand corner, left-hand corner was cash flow. Next quadrant is the most important projects you'd like to complete by year end. So stop the presentation and do that. Bottom left-hand corner, cleanup and tolerations. Now we did the toleration exercise on day 1. So if you're at a point that you've done that exercise and you stopped, look at your tolerations. I want you to get the 10 most important tolerations or messes that you want to clean up by year end and rank them and do easiest first. And I want you to start with easiest first. That way you can have some momentum. Right-hand corner, bottom quadrant, right-hand bottom quadrant in the corner, start thinking about your strategic planning. What would it take to set up 2014 as the best year ever? What's this strategic planning with your team? What do you have to put in with your marketing calendar? But most importantly, start to think of time off for you. What can we do to block off time off for you? So go ahead and pause that and just brainstorm for a little bit. And if you want to, after you're done, hopefully you've restarted, I want you to think through 3 things. What year-end gifts do you have planned for your best referral sources? Do you have free time or time off booked for you for the rest of the year? And if there are 3 things that you could do to ensure that this would be the best quarter of the year, what are they? Looking at all the things that you've identified, what 3 things would make this the best quarter of the year for you? And just pause the presentation right now and just complete that exercise. Great. Now hopefully you have paused it and done the exercise as I suggested. Everything on there right now looks really critical, really important, but what I'd like you to do is look at the 10 most important and just take a scrap paper and write out the 10 most important. My suggestion is that your first one should be cash flow. Your second one should be a Kaizen process. I would like my third one would be your process flow chart. I'd like to see you put that in play. And 4 is planning out strategic planning for 2014. So I'd really like to see those 4 in there. And then what you want to do is go ahead and work with your top 10 crucial goals. And the worksheet for that you should have with this. And if you don't have it, email Mike. He'll get it to you. And he'll get you a fillable PDF in. And my request is that you do the fillable PDF and send it to Mike so that he can share it with Mark and I so that you have that. Great. We're almost done. So what I'd like you to do is think about our next Dominate Your Market focus is going to be really around breakthroughs in marketing and creating innovation in your practice. I would these are the work days for 2014. We discussed continuing the class together, and everyone seemed to be in agreement that we would do another year, so the entire class is committing to another year. You'll have to make a decision whether that works for you because you weren't there, obviously. But for most of the class, we're moving forward for another year together, and these are the dates for 2014. And this is your homework. Submit your top 10 crucial goals to Mike at Mike@Atticus Online. We would suggest that you schedule 3 calls with Mike, 30-minute calls with Mike as your resource advisor for this program. Number 3, bring completed your process flow chart to the next workday. Calendar, of course, your 2014 workshop dates. Your homework assignment for the next class will be Predictably Irrational by Dan Irely phenomenal book, very intriguing. We're going to use that book to set up certain conversations in Dominate Your Market. So I think it's a terrific book. And then last but not least, if you know someone that'd be a good fit for Dominate Your Market or for the Practice Builder or the Practice Growth Program, please let us know. In particular, since this group has been a tremendous success for our company, but more importantly, a tremendous success for people that participate in it, we are starting a second Dominate Your Market group. So if you know somebody that you think meets the criteria, we would really appreciate the introduction to them. You can either email me at steve@atticusonline or Mark, and we can talk to them about what that looks like. With that, I hope this was a really great review for you, and we look forward to seeing you at the next program. Thank you.